$60,000. Gone. And after 2 years of court victories, police reports, and collection agencies, a family in Massachusetts still hasn't seen a single penny back. They won. On paper, they won everything. And yet the man who took their money is still out there, living his life, dodging court dates, and hiding behind a shell company with nothing in it. This is one of those stories that makes you realize winning a lawsuit and actually collecting on a judgment are two completely different battles, and most people have no idea the second battle even exists until they're already losing it. Let's set the scene. A couple, older, probably trusting, the kind of people who save carefully and finally decide to invest in their home, hired a contractor for a major renovation. The deposit alone was $60,000. That's not a small check. That's years of savings for most families. They handed it over in good faith, and then the contractor vanished. No work done, no communication, just gone, along with their money. Their adult child stepped in to help, filed a lawsuit, navigated the courts, and after what was likely an exhausting legal process, actually won. They got a judgment against the contractor personally and against his single-member LLC. They even got something called a writ of execution, which is essentially a court-issued permission slip to go collect what's owed. That's not nothing, that's actually a significant legal accomplishment. Most people don't even get that far. But here's where the story gets painful. 2 years have passed since that judgment. 2 years. The contractor doesn't show up to court. He claims he has no personal assets. He points to his LLC and says, essentially, there's nothing there to take. The collection agency they hired sent letters, just letters, and got nowhere. The police said it's a civil matter, and a basic search of the LLC turned up nothing useful. So this family is sitting on a piece of paper that says they're owed $60,000, and it might as well be written in invisible ink. This situation is more common than most people think. The gap between winning a judgment and actually collecting money is one of the dirty secrets of civil litigation. Attorneys will sometimes tell you up front, getting the judgment is the easy part. The hard part is enforcement. And when you're dealing with someone who is sophisticated enough to structure their finances specifically to be uncollectible, that enforcement process becomes a chess match where your opponent has had years to set up the board. So let's walk through the legal tools this family has been researching because they've actually done their homework, and some of what they're asking about is genuinely powerful. The first tool is something called supplementary process under Massachusetts General Laws, Chapter 224, Section 14. This is a mechanism that allows a judgment creditor, meaning the person who won the lawsuit, to drag the judgment debtor back into court and force them to answer questions about their finances under oath. And here's the part that gets interesting. If that person ignores the court summons, a judge can issue what's called a capious warrant. That is an arrest warrant, not for the underlying debt. You cannot be jailed for owing money in Massachusetts, but you absolutely can be arrested for contempt of court for refusing to appear when ordered to do so. So when this contractor keeps skipping court dates, he's not just being difficult, he's potentially walking himself into handcuffs. The family's question about whether Norfolk County District Court would actually issue one of these warrants is the right question. And the honest answer is, yes, they can and do issue capious warrants in these situations. The key is filing the right motion and making sure the court understands the pattern of deliberate avoidance. The second tool they're asking about goes after the LLC itself. The contractor's defense seems to be that he personally has nothing and that the LLC is a separate legal entity. In many cases, that's true. The whole point of an LLC is to separate personal and business liability. But Massachusetts law has long recognized that this protection can be stripped away when the LLC is being used as a fraud vehicle. The legal doctrine is called piercing the corporate veil. A case called Attorney General v. MCK Inc. is one of the leading Massachusetts cases on this, and it lays out factors that courts consider. Things like, was the LLC actually capitalized? Did it have real operations? Were corporate formalities followed? Was it used to perpetrate a fraud? In this situation, the facts line up remarkably well for veil piercing. A single-member LLC that took a $60,000 deposit it had no ability or intention to fulfill, with apparently no assets or real operations. That's not a business, that's a shell. A good attorney making this argument to a Massachusetts court has a real foundation to work from. The third tool they're researching is one that a lot of people don't know exists: the Uniform Fraudulent Transfer Act, which in Massachusetts is codified at Chapter 109A. This law exists specifically for situations where a debtor tries to move assets to family members or other parties in order to hide them from creditors. And here's the critical piece. In Massachusetts, fraudulent transfers can be unwound for up to 4 years from when the transfer was made. So even if this contractor, in the months before the lawsuit was filed or even after the judgment was entered, moved money or property to his wife or family members, those transfers can potentially be clawed back. The family's concern is that they don't have proof of specific transfers yet. But that's what post-judgment discovery is for. Once you're back in court, you can subpoena bank records, real estate records, financial documents. You can depose the contractor's spouse if necessary. The discovery process can expose a paper trail that the contractor thought was safely buried. This is a legitimate and frequently successful enforcement strategy when a debtor has been hiding assets within the family. Now, the fourth area they're asking about is the one that could change everything: criminal liability. The local police told them it's a civil matter. And frankly, local police often say that when they don't want to deal with financial crime. But here's the legal reality. Under Massachusetts General Laws, Chapter 266, Section 30, larceny by false pretenses is a crime. If someone takes money from you by making false representations, like promising to complete a renovation they had no intention or ability to complete, that can be criminal, not just civil. The family's instinct to go directly to the Norfolk County District Attorney's Office rather than local police is correct. The DA's office handles complex financial crimes. They have investigators with the tools and authority to look at this differently, and the detail about multiple victims matters enormously. If this contractor has done this to more than one family, which when someone operates this way is often the case, prosecutors are far more likely to open an investigation. A pattern of behavior transforms this from a contract dispute into a criminal enterprise. The family should compile everything: the contract, the canceled check or wire transfer, the judgment, documented attempts to collect, and any information about other victims they can find, and bring that package directly to the DA. So what does all of this mean for anyone watching who might be in a similar situation, or who wants to make sure they never end up in one? First, understand that a judgment is the beginning of the collection process, not the end. When you sue someone and win, the court doesn't send a check. You have to go get the money. That means using every enforcement tool available and not stopping after 1 or 2 attempts don't work. Second, don't rely on a collection agency for serious debt collection. Collection agencies are designed for high-volume, low-value debts. When $60,000 is on the line and the debtor is sophisticated, you need a lawyer who specializes in judgment enforcement. Not just any litigation attorney, but someone who knows supplementary process, asset discovery, and fraudulent transfer law. Third, never assume it's too late. 2 years feels like a long time, but judgments in Massachusetts can be valid for 20 years and can be renewed. Fraudulent transfers can be unwound for 4 years. Criminal complaints have their own statutes of limitations. Time is not necessarily running out, it depends on the specific tool. Fourth, document everything and look for patterns. If you suspect someone has defrauded multiple victims, that information belongs in front of a prosecutor. One victim is a civil dispute. Multiple victims is a pattern of criminal conduct, and prosecutors respond to patterns. Finally, and this is the hardest one for families in this situation, don't let emotional exhaustion win. These contractors, these landlords, these employers who game the system are counting on you getting tired. They're counting on you running out of money for legal fees and giving up. Sometimes the most powerful thing you can do is refuse to stop. Use every tool. Escalate every avenue. Make it more expensive for them to keep hiding than to just pay what they owe. If something like this has happened to you, If you won a lawsuit and can't collect, if a contractor took your money and disappeared, if you're sitting on a judgment that feels worthless, share this video with your attorney and ask specifically about the tools discussed here. Supplementary process, veil piercing, fraudulent transfer claims, criminal complaints to the DA. These aren't long shots. They are real mechanisms designed exactly for situations like this one. And if you want to see more real legal cases broken down the way we did today, cases where people are fighting back against fraud and financial abuse and learning how the law actually works in their favor, make sure you subscribe. We cover stories like this every week because knowing your rights is the first step to actually using them.